I've done a lot of criminal defense work on appeal, and I continue to work very hard in this area, in this aspect of litigation practice. One of the challenging things I find in criminal appeal work is finding a narrative, a story, something compelling to bring forth on appeal. And so for today's interesting appellate issues video, I'm going to talk about one very illustrative case from a decision recently published by the Appellate Division of the New York State Supreme Court. The defendant was convicted after trial of 2 drug possession charges and sentenced as a second felony offender to the maximum permissible statutory range of state prison. That was 12 years for a beef felony, nonviolent felony of criminal possession of controlled substance. One of the bases for his appeal was the excessive nature, in his view, unduly harsh or severe under the circumstances of that 12-year term of incarceration. The Appellate Division, in this decision that came out in just this month, rejected defendant's request to modify his sentence in the interest of justice, considering his age and health. Well, the record doesn't clarify what his health issue was, but a quick check of a different website, which is Incarcerated Lookup, managed by New York State Department of Corrections, shows that this gentleman, whose name I'm not giving you, is now 62 years of age. He'll be actually 63 coming up in a couple of months. So a 12-year sentence for a 63-year-old is quite significant. And yet the Appellate Division found that that was not excessive, even though he has some health issues, because he has a lengthy criminal history going back to when he was 15 years of age, and the majority of his offenses are drug-related. I just find that extremely sad. It's very hard to maintain one's focus and positivity doing criminal defense work when confronted with facts like this. We all know that healthcare in the prisons isn't great. So someone who goes into prison at the age of 63, and I'm saying this as an oldster myself, I just turned 65 this year, for 12 years, may not come out, may die in prison. That's a reality. Hopefully he will. But that was not enough to persuade the Appellate Division to reduce his sentence in the interest of justice. Excuse me. The only other issue I have time to fully discuss with you today is a claim in this decision of ineffective assistance of counsel. I'm going to start with the upshot because the court did deny that, and they said that the trial lawyer for the defendant moved to suppress evidence, vigorously cross-examined the prosecutor's witnesses, and made cogent opening and closing statements. And this was enough to satisfy the appellate court that the defendant received meaningful representation, even though he failed to object to some of the prosecutor's proof on a different issue. And as to that particular argument, the appellate court found that an objection had little or no chance of success. So a defense lawyer should not be faulted on appeal for remaining silent when a prosecutor puts forth evidence that could have been objectionable. Anyone who sat in a criminal courtroom knows the tedium of a lawyer, be it a prosecutor or a defense lawyer, who objects to everything and just slows down the process of the trial by continually objecting. On the other hand, you don't want a lawyer who basically functions as a patsy for the government and fails to object to anything that might indeed get evidence thrown out. There's no point to that. If you're a defense lawyer, your job is to defend. Your job is to put up a fight. Your job is to hopefully win and gain an acquittal. So these are just two illustrations of how criminal defense work is tough at trial, and it's certainly tough on appeal because you're often confronted with facts that just are stubborn and defy easy resolution. In this case, the two examples I gave you were a defendant who had a lengthy criminal history starting at the age of 15. He was tried and convicted at the age of 62 or 61, it looks like, of a Class B felony drug charge. And he got the maximum of 12 years in prison. And the appellate court found that that was not unduly harsh and severe, notwithstanding his advanced age and his health issues. And the other issue that I just covered was ineffective assistance of counsel, where the appellate court found that, hey, maybe a defense lawyer didn't object enough, but you know what? He gave a very cogent opening and or she, a very cogent opening and closing statement, and he vigorously cross-examined the people's witnesses, and he made a motion to suppress evidence. Therefore, the appellate court was satisfied that that defendant received meaningful representation. These are tough issues, but I'm the kind of lawyer that is not afraid of taking them on again, even if a prior effort may have not been so successful. That's why I continue to do appeal work and I enjoy it. Thank you for stopping by, and stay tuned to my next episode of Interesting Appellate Legal Issues.